Hi, everyone. I'm Mark Levine, and welcome to the NYC Real Estate Podcast. I'm your host. I'm also a New York City property management professional for the past 30 years. Just a quick note, I've joined TikTok and I've been putting some great videos out there. So if you want to check me out at Mark in Real Estate, super easy, at Mark in Real Estate. I'd love to have you as part of my community on there. Today, since we're in the first parts of January, just wanted to go over some things related to the real estate market here in New York City. One of them is the heating requirements. So I did a video on TikTok today about heating requirements in New York City. And if you're not familiar with them and what the requirements are, I'm going to quickly go over them. So the heating season is from October 1st until May 31st, and it's broken down into two time frames during the day. We have the daytime period, which is considered to be 6 a.m. to 10 p.m. And when the temperature drops below 55 degrees outside, we have to maintain at least 68 degrees on the interior temperature. And then from 10 p.m. to 6 a.m., that is considered to be the nighttime temperature. So, regardless of the outside temperature, we have to keep it at least 62 degrees inside. I always say if you have a problem and you're living in a unit that doesn't have the minimum thresholds met, first reach out to your management company and your landlord. And then, if all else fails, go to 311 and put it in complaint. And hopefully that will initiate a repair. And of course, sometimes there are extenuating circumstances with gas shutdowns, but those shouldn't last too long. And you should have a property management company or a landlord who is responsible and has systems put into place to get you back up there. Also, it's a good time to remind you of the hot water requirements, which is a minimum of 120 degrees inside all residential units. So just if it's too hot or if it's scalding, I'm sorry, if it's scalding and too hot, or if it's too cold and you're not reaching that 120 degrees, that would be something that you could also reach out to. There's two things that I also want to cover. Before we get into that, if you want to email the show, you could do that at nycrealestatepodcast@gmail.com. Again, that's nycrealestatepodcast@gmail.com. It's been really fun endeavor here doing these podcasts for the last few years, and I'm looking forward to 2026 bringing some more. I'm going to read out an article. Cole Schatz, a real estate a law firm, did a great article written by Jordan J. Metzger and Gwendolyn J. Goodyear, and it was on December 23rd. And what they covered was the COPA changes that are coming. And by COPA, that is the Community Opportunity to Purchase Act. So I'm just going to read this article. I thought that it laid it out really well. There's no reason for me to put my own 2 cents into it. But if you're not in front of a computer and you want to listen along, I would love to have you stay the whole way. So this blog post, as I said, was from Cole Schatz, and I'll leave a link in the description of this podcast. And if I put this up on YouTube, I'll put the link to the page on the blog also on there. With New York City Council's recent passage of the Community Opportunity to Purchase Act, also known as COPA, comes a new statutory framework that grants certain community-based organizations the rights to purchase qualifying residential buildings before, or in some cases, in place of private buyers. Its anticipated implementation in 2027, absent a veto by the mayor of New York, will fundamentally alter the process, timing, and risk profile of selling certain properties in New York City. COPA reflects a significant shift in policy in New York City's approach to affordable housing preservation and open market transactions. Owners, investors, and developers should understand how the legislation is structured and COPA's practical consequences. So, how does COPA work? At its core, COPA positions certain qualified entities as certified by the New York City Department of Housing, Preservation, and Development, also known as HPD, with leverage to first purchase specified residential properties, each referred to as a covered property, which I'm also going to describe as we go. Qualified entities may include joint ventures between community organizations and private developers, provided the community organization maintains a controlling interest. Upon a sale to a qualified entity, HPD and the Department of Finance will be required to waive certain municipal charges, taxes, and fees associated with the transaction. COPA does not require owners to sell at below market prices. Rather, the legislation inserts qualified entities into the front end of the sale process and, in limited circumstances, provides a right of first refusal if an owner later accepts an offer from a non qualified buyer. The result is an extended and highly regulated timeline coupled with the new compliance obligations and enforcement risk. Let's talk about covered properties. COPA applies to Class A multiple dwellings with four or more dwelling units, subject to several important limitations and timing thresholds. Owner occupied properties for residential properties with five or fewer units are expressly excluded. Within the first year of COPA going into effect, a property becomes a covered property if it meets a specified distress or regulatory criteria, including participation in HPD's alternative enforcement program, being subject to certain enforcement orders or foreclosure actions, recent harassment findings, or affordability restrictions set to expire within 2 years. Beginning 1 year after the legislation's anticipated 2027 effective date, COPA's scope expands. Properties may qualify as a covered property based on hazardous or immediately hazardous housing violations, expiring affordability restrictions, or other criteria established by HPD through future rulemaking. HPD is required to provide annual notice to owners whose properties are deemed covered property and must always provide owners with an opportunity to challenge such determinations. So, what are the qualified entity requirements? COPA distinguishes between not for profit and for profit qualified entities, both of which must be certified pursuant to HPD rules. Not for profit qualified entities must generally be 501c3 organizations with demonstrated experience owning and managing residential property, including affordable housing, coupled with requisite financial capacity and commitment to housing preservation, in addition to satisfying other HPD determined criteria. Similarly, for-profit qualified entities must demonstrate the capacity to acquire, rehabilitate, and manage regulated housing, maintain affordability restrictions, and show experience in affordable housing preservation. There are certain owner obligations prior to the sale of a covered property. Before taking any action to sell a covered property, an owner must deliver a formal notice of intent to sell to HPD and all certified qualified entities. Such notice must include detailed ownership information, unit count, income and expense data, and a deadline of no fewer than 25 days for qualified entities to submit a statement of interest. If no qualified entity timely responds, the owner is free to proceed with a sale in the open market. However, if a statement of interest is submitted, the owner is prohibited from marketing or selling the property outside of the COPA process during the statutory review period. Once a qualified entity submits a statement of interest, the parties must enter into a confidentiality agreement, after which the owner is required to provide extensive due diligence materials, and that includes rent rolls, financial statements, inspection reports, litigation history, and harassment findings. The qualified entity then has 80 days, subject to extension by HPD, to submit a bona fide offer. During those 80 days, the owner may not pursue other offers. If an offer is made, the owner has a limited 10-day period to accept, reject, or counter. An acceptance or counteroffer triggers an additional 30-day window to enter into a contract of sale. If all offers are rejected, or if a qualified entity fails to time the close, the owner may sell the property on the open market to a non-qualified purchaser under COPA, subject in certain circumstances to a right of first refusal. Let's talk about the right of first refusal. If an owner receives an offer it intends to accept from a non-qualified buyer within 1 year after rejecting a qualified entity's offer, the owner must provide notice of that offer to HPD and the qualified entity that previously submitted a bona fide offer. The qualified entity then has 15 days to elect to match the offer and must close on the identical terms to that initial offer. If the qualified entity declines or fails to close, the owner's obligations under COPA are satisfied. COPA expressly provides qualified entities with a private right of action to enforce its provisions. Owners found to have violated COPA may be subject to uncapped civil penalties, injunctive relief, and liability for the qualified entity's attorney's fees and expert costs. And they list out potential challenges for owners. So they say, although COPA narrows its initial application to certain properties, the legislation imposes significant restrictions on owners. The regulatory expansion risk. COPA grants HPD broad authority to expand the definition of what's considered to be a covered property through future rulemaking. It does raise the possibility of additional buildings becoming subject to the legislation. Litigation exposure. If disputes over compliance, timing, or whether an offer is bona fide could result in significant litigation, and maybe that could also lead to a delay in sale. Financing questions. COPA does not include whether qualified entities will consistently have access to financing sufficient to acquire market rate or predominantly market rate buildings. They also make a note of there could be a possible impact on marketability. Mandatory notice and waiting periods, including the right of first refusal, afforded to qualified entities, interfere with traditional marketing efforts and may discourage potential buyers, particularly in time-sensitive sales. The note also challenges to HPD determinations. Owners will need to track and, where applicable, challenge HPD determinations that qualify a property as a covered property. They say that COPA represents a rebalancing between private property rights and community-based housing preservation. Owners and investors must factor COPA compliance into planning, diligence, and pricing. The true impact of COPA will depend not only on the statutory text, but on how HPD implements and enforces COPA in practice. So as you can see, COPA, if it is actually signed into law, and we're expecting this to come into 2027, it's going to shift the landscape of how we market, how we operate, how we ensure that we're as violation free as possible, which we always do. But it's real. If you're having so many violations, now you get put into these programs with New York City, with HPD, it could really hamstring ownership when they need to get out. And I also don't know how this is going to affect any 1031 exchanges if the timing is pushed off and getting those in play within the appropriate timeframes on a market sale that happens now. So that's the COPA discussion. I'll, as I said, leave a link to that. The other thing that I covered recently is updates to Local Law 152 and the gas inspections. So right now we're in the second real cycle of gas inspections. We've had one set of gas inspections that went from 2020 to 2023, and now we're in the second between 2024 and 2027. So every year, in case you don't know, there are a series of buildings that are required to do periodic gas piping inspections in all common areas. It's a sensor test. It's not a pressure test. This year, we're in 2026. This is considered to be the third grouping. So this is the third year of that second roundabout cycle. And if your building is in community boards number 4, 6, 8, 9, or 16, those buildings would have to do an inspection and also file that with DOB. DOB is changing the system a little bit starting very soon. They're going to be putting the inspection uploads and all the other information into DOB Now. Right now, it's been just through a normal website and you upload all the information. But now, since DOB Now is getting involved, and that's where all of our compliance up to this point sits with elevators, boilers, tenant protection plans, permits. We have garage inspections. We have a whole host of things that are on the DOB Now platform, and now this is going to be on there. So there's been no fees for anything city related or filing related up to this point, but that's about to change. So there are $35 fees for the first three items here. To file a certification of the gas piping system periodic inspection, $35 fee. Also a $35 fee for an extension request to submit the initial certification or an extension request to correct conditions. When we file them and we have that GPS 1 and that GPS 2 form on the sensor test from the master plumber that performs this, they have to either say that there were no conditions noted that required repair, or if there were conditions reported. And depending on the level of severity on that, you could either get a red tag and the building could be shut down, or you could be granted an allowance of time to have the plumber or another plumber take care of it. The last $35 fee would be for the gas piping certification of correction. And then we bump up a little bit. There's a $375 fee if we're filing a certification of a no gas piping system in the building. And the good news is that once you do that, if you don't have gas piping in your building and you're not, in your eyes, subject to this local law 152 gas inspection because you don't have that gas piping, that's just the application, the 375. And then once they approve it, then you would come out of the system. And there's also another $485 fee that's been instituted if we want to file for the documentation regarding no gas service in the building. So if you're up for your inspection and maybe you have your service turned off and there's no service right now to test, then you would put that in and that would be a $485 fee. I'm imagining that if you return gas service back in the building, you'll have to, then go through the process of this. So the two important changes are DOB Now, permits, uploading and fees. So all of that information, is super helpful to know and just to navigate. And if you're managing multiple properties, just know that it's going to be on the DOB Now system that you're probably already living in. So if I want to just quickly go through next year's community board numbers to finalize this cycle in 2027, that's group 4. Community board numbers 11, 12, 14, 15, and 17 are up. So this year, 4, 6, 8, 9, and 16 are the ones that we're focusing on. We bulk bid all of our buildings at one time to various plumbers, and we try to get the best pricing on portfolio basis. So if you need a connection with a plumber who we've already kind of vetted and gone through the proposal stages with, please let me know. Send me a note. More than happy to talk to anybody. So that's my quick update for today. Today is January 13th, 2026. I know it's almost mid-January, but I hope everybody had a good new year, and I'm looking forward to 2026 having a lot of information, a lot of new business, and a lot of things that we could talk about. Till next time.